the way the living trust takes into place, for example, is let's say Brandon creates a living trust. Because he's engaged, he's not married yet, Brandon were to pass away tomorrow. And let's say Brandon doesn't have a will. Then in order for Brandon's assets, his estate, to go to his children, it has to go through the probate process, provided it's above the $184,500,000 limit. It's gonna go through this process, and when it comes out of the process, it's gonna be reduced by the amount of attorney fees and executor fees and court fees, etc. But because his children are minors, in order for it to go to his children, somebody has to apply to be the guardian of the estate before it can go to the children. And then that person has to hold on to those assets till his children are 18 years of age. Even if he had a will and he named his children as beneficiaries, it would still have to go through the probate process. But what Brandon could do is he could create a living trust, let's say called the Brandon Family Living Trust. And in that living trust, he can say, I want my assets to go to my children, but I want it preserved in trust till they turn a certain age. Now, what happens when Brandon passes away, because those assets did not belong to Brandon, it belonged to the Brandon Trust, it was a separate entity, there's no probate process.